right, can everybody hear? Are we on? Here? Okay, good. Okay, great. Well, thank you for checking in. I appreciate everyone taking the time to log on. There have not been, how do I say this? There's been a lot of filings this week. There's been a lot of back and forth, but nothing particularly significant has happened. It's not, for example, like last week, where we had the huge decision by the CPUC, two of them, in fact. One of them staying a $200 million fine, and then the other one, which was even more important than that, the decision to approve the plan. So the only really significant thing that happened this week, there were a bunch of filings that went back and forth, and I'm happy to answer any questions about those. But the most significant thing that happened this week was we got our first sense of where we are on voting on the plan. And what happened there was that 5 of us who represent a significant number of people, together the 5 groups represent over 31,000 of the 77,000 victims, we got our initial numbers back on the voting. And these are a little bit out of date. They're about 6 or 7 days old because it takes Prime Clerk some time to process. But the total number of votes cast were about 20,500. And of those, 98.7% had voted in favor. So it was overwhelming. I think other attorneys will have different numbers. There are a couple of groups, smaller groups, that are opposing the plan. I think together they probably have 1,500, maybe 2,000 people. So those groups are opposing. I don't know how their voting is going. They didn't reveal it. But even if they were all to vote and they were to get all their clients to vote, which is very unlikely because we've been very proactive in asking our clients to vote, and only about 2/3 of ours voted. But even if everyone in their group voted, we're still looking at about 90% in terms of an acceptance rate. So right now, according to the statistician that has been hired to monitor this, it's obviously nothing's a sure thing, but certainly we're very close to being a sure thing in terms of the plan getting approved. So what we're working on right now, and where most of our focus is trying to get the restriction of rights agreement finalized. And this is something that we talked about before, but as you know, when large blocks of a stock that are owned, it can have a very negative effect if someone who owns, for example, 10% of a company dumps their entire position. That would cause the stock to go down dramatically. Very well may come up, but anytime that you own a significant amount of stock, you don't want to see that. So when they do this underwriting, what happens is they put in certain restrictions, and you're only allowed to sell a certain amount of the stock at any one time. So that's the restriction of rights agreement, and that's what's being worked on right now. I've spoken with both the TCC and some of the other attorneys involved several times this week. It looks like we're making progress. We're not quite there yet, but we're getting very close. The other important thing is that the trust document, which is a bit of a formality because we know what's in it, but we haven't had the final document, that is being finalized. I got a copy of it today. We're working on it with the trustees' attorneys, and hopefully we can get that finalized and approved by Monday at the latest. So that's where we are overall. There are a few questions, and so let me answer those, and then we can talk. We can just open it up and take your questions. So here's the first question. Mr. Singleton voiced optimism that there would be a high level of reimbursement, maybe 90 cents on the dollar. Is that still true? Is he also expecting the claims to be cut back significantly during the review process by the trust administration team? So that's a good question. In terms of claims cut back, it's important to remember that the amounts that we ask for are our demands. And generally, when you make a demand, it's reduced. It's very rare that you would make a demand in any type of negotiation and get the full amount. So what we're going to do is we're going to ask for the most that we think we can without being unreasonable. Obviously, we don't want to make a, for example, the $260 million Emerald claim, but at the same time, the experts that we hire are our experts, and their job is to present your case in the light most favorable given the law. So we certainly are not going to make claims that are not justified by the law. We're certainly not going to make claims that are patently unreasonable, but we're going to err on the side of asking for as much as we can for each one of you. As a result of that, the claims administrators are going to come in and they're going to say, I understand that your expert has valued it at 4x, but typically these are valued at 2x, and so 3x may be where we end up. That's just an example. I'm certainly not saying that in every case there are going to be reductions, but again, when we prepare these, the experts that we hire are hired to maximize the value of your claims, and they wouldn't be doing their job if they underbid it. So one thing I can promise you is we're not going to ask for too little in any of your cases. So that's what I would say in terms of, is the trustee and claims administrator, are they going to reduce it? I think they will reduce it, but I don't think that is going to be a huge reduction. In terms of the 90 cents on the dollar, we're hopeful that it's going to be 100. In other words, we make our initial demand, then the claims administrator processes it. They look at what is typical for housing in that area, for example, and then they come up with what they think it should be. We go back and forth, we get to a final number, and then eventually each of you will accept that. Or if you don't, we go to arbitration and the arbitrator renders an award. Eventually we get to what we're going to call a final claim number. That's what we're talking about when we say 100 cents on the dollar, the amount that the claim has been determined to be worth. Again, I'm hopeful we're going to get 100 cents. We may get 90, we may get 95, but we are still very optimistic that we're going to get a high percentage of that final claim. Again, hopefully it's 100. We can't guarantee that. Next question is, Mr. Singleton has said that if the trust is funded by August 29th, it's possible that 50% of the claims could potentially be processed and paid prior to the first of the year. In the Saturday town hall, 2 different attorneys stated that they didn't expect claims to be paid out until early 2021. Please clarify. Good question. So here's where we are in terms of what we think is going to happen. Right now, we are projecting that August 29th, which is the date that's set forth in the agreement we signed with PG&E, will be the date that the trust is funded. The only potential hindrance is if, and I know we're all excited about this, there is now an opening up from COVID, and hopefully that keeps going smoothly. But there is a possibility, it's not a huge possibility, but there is a possibility that there could be some type of a horrific second wave that could hit in August. So if, for example, we have a situation where we reopen later in May or early June, as the various governors are talking about, and things go along, and then all of a sudden in mid-August, right before August 29th, we have a disaster like we had back in March when the Dow lost, I think it was 7,000 points or high 6,000s in one day, by far the biggest loss it's ever had. If we were to have something like that right before the stock was going to be issued, then we would work with PG&E and wait until it's a better time to issue the stock and to fund the trust. But barring something like that, we fully expect it to be done by August 29th. Assuming that happens and it's funded by August 29th, both the trustee, Justice John Trotter, and the Chief Claims Administrator, Kathy Yanni, have given me their word that they would begin paying as soon as claims were ready. And one of the reasons we were so excited 2 weeks ago that the court approved that $19 million advancement by PG&E is that it gave Justice Trotter and Ms. Yanni the resources they needed to get their claims administration staff up and running. As we talked about, they're going to hire somewhere between 200 and 250 people to perform all of the tasks that need to be done to evaluate, to vet, to come up with the numbers on these claims so that the claims administrators can make the final decisions. And the reason that was so key is that they're beginning that process now, so they will be ready to go as soon as the trust funds. Typically, what will happen is once you get a final claims amount, the payment will be made within 30 days. So I do believe that if the trust funds on August 29th, we're looking at payments being made sometime in late September and early October for the first few cases. I would expect that we're going to see more and more submitted and finalized as the months go on. The goal is to pay out 50% within 6 months. So we're looking at actually about February or March, not January. But again, that goal is to have 50% paid out within 6 months, and then the other 50% would be paid out in the second 6 months. And we want to have everything paid out by the end of 2021. Obviously, that's very aggressive. And, you know, I don't know that that's going to be met, but you certainly have a better chance of maximizing production if you set very high goals. So that is certainly an aggressive goal, but we're going to do everything we can to meet it. And again, Justice Trotter and Kathy Yanni have given me their solemn pledge that it would be done. So I'm very optimistic that we're going to start payments in late September, early October. Then the last question was, how would a payout be handled for a family if each family member is listed? That's a very good question. So we have two different methods for submitting claims when you have a family. Typically, you're talking about a nuclear family that has similar damages. So, you know, in a classic example, you'd be talking about husband, wife, couple of kids, 2 or 3, and they all, for example, suffered the loss of a home. So they all have similar losses. Obviously, the adults own the real property and the majority of the personal property, but the minor children certainly have claims for some personal property and for their emotional distress. So what will happen is that the claims administrator will come up with a number that works for everybody, give it to them, and then they can disperse it. That's usually what happens. There are certain cases where it makes more sense to do it separately. And that can be in the unfortunate situation where you have a couple that splits up. You know, that does happen. And obviously it's never something that is we hope for, but it happens from time to time. And so we do that. You also have situations where sometimes you'll have different properties where, for example, you'll have a trust that owns a couple of properties, and then you'll have an individual who has an interest in the trust but may own a separate property. Usually in that situation, we would try to get 2 separate awards. So you would have the one for the amount owed, or the properties owned by the trust, and then the individual would take their portion of that. And then for the one that was owned separately, you would have that individual who would recover from that. So it's a case-by-case basis, and we're happy to handle it however you want. We've had people say, look, we want separate awards for every person in our family. We're fine with that. Typically, we do it, if it's a nuclear family, you get one amount, but we can certainly handle it any way you like. The last thing I wanted to raise was this. One of the things that's been brought up a number of times in various media outlets is a conflict of interest that one of the attorneys in this case, Michael Watts, is alleged to have. And the reason I want to address it is that it keeps coming up. And so I've had people ask me about it. And so I just wanted to let everyone know what my thoughts on that are and what our relationship is with Mr. Watts. We have worked very closely over the last few months, I would say probably 6 months, with Michael Watts and a couple of other firms. Together, we're known as the Consenting Fire Claimant Professionals. And the reason for that is this. The TCC is made up of several individuals who are represented by attorneys. And the problem that was happening in the early negotiations is that the attorneys for the TCC represented a very small number of victims. Overall, it was, a few thousand at most. I think it was 3,000 or 4,000. So the problem was the TCC would make representations to PG&E. PG&E would talk to some of the other attorneys, like Mr. Watts, he has a consortium of several firms. They represent 16,000. Like our group, we represent 7,000. Like Amanda Riddle, Dario De Gataldi, they represent 6,500. Other groups. And we would, at times, not agree with that. And the problem from PG&E's perspective is they're saying, well, wait a minute, we're negotiating with the TCC, but they don't really have any power. Their lawyers only represent a few, relatively speaking, victims, and yet there's this other group of attorneys who have a lot of experience in fires and who represent the vast majority of the victims. We need to bring them in as well. So what we did was we created the Consenting Fire Claimant Professionals, is the name of the group. I don't know who came up with that, but that was just what it was called. And that was made of 13 firms that collectively represented over 70% of the victims. And the idea of getting so many people together was we felt like if we all agreed and we talked with our clients and our clients were in favor of something, then we felt that we would be able to secure the 2/3 of votes. So Michael was very instrumental in getting that done. And he's also been very instrumental in negotiating some of the agreements. He and I have attended every mediation session. There have been a handful of attorneys that have been there for all of them, but he's definitely been one of them. And I think he's done an excellent job. So he really has been a pleasure to work with. It came up in December when the bondholders made a counter proposal to equity that there were certain bondholders that had an interest in a line of credit that Michael Watts had for his firm. And let me just explain how that works. Some of the more national firms have lines of credit that finance their operations. In Michael's case, they have a line of credit for $100 million. In our case, we do not. We are very fortunate. We've been able to completely self-fund, and so we have not had to borrow any money to pay the very high expenses of this case and our other cases. For example, in this case, we've spent well over $10 million, but again, we've been able to fund that out of the earnings that our firm gets on our other cases. We do have lines of credit available in the event that we need them. For example, I don't have any lines of credit, and my firm doesn't have any lines of credit with hedge funds or anything like that, but we do have the kind of standard business lines of credit with banks, and I have them at JP Morgan, First National Bank, which is a subsidiary of Royal Bank of Canada, and Citibank. So, and if anybody wants that information, I'm certainly happy to provide it. Again, we haven't tapped into those, but we have them available just in case. I'm a big believer that you always want to have contingencies in place. So anyway, Mr. Watts and his firm have this line of credit for $100 million. When you have those lines of credit, there are other interests that can buy into them. And so what happened here was that a couple of the bondholders, Apollo and another firm, I believe it's called Centerbridge, bought into that line of credit. Now, it's important to remember that it's not on the fire cases, it's for general operation. And by having the line of credit, you don't have any interest in that firm's ability to make decisions. One of the things about being a lawyer is you can't have any non-lawyers in any position to make decisions for clients. And that's a requirement of every bar in every state, California, Texas, Missouri. For example, I'm licensed in 4 states. those 3 in Minnesota, and in all of those, there's the same requirement. So what happens though is that a lot of these firms will have these lines of credit, and there have been many opinions saying that as long as they do not have the ability to influence what happens, no control over decision making, it's not a problem. What happened here was the no voters seized on this and turned and basically tried to make it into something that it wasn't. Michael had disclosed all of this to his clients via town hall. It's up on his website if anybody wants to look at it. He'd also sent out letters. This was in December, once this came to everybody's knowledge. Nobody did anything with it. And then about 2 weeks ago, one of the very prominent individuals who is a no vote gave it to the press and said, you know, this is a huge thing. I discovered this. And so the press reacted as saying, well, this is a secret that's come to light, et cetera, et cetera. Turns out, again, that's not the case, but it has been published quite a bit. And so what I wanted to read was the opinion that was in today's Bloomberg article by a law professor of ethics at Cornell. This is a gentleman named Bradley Wendell. He specializes in legal ethics, and he said the Watts-Guerra, that's the name of the firm, financing poses no conflict of interest because the investment firms have no control over his decision making. So, you know, that's kind of my view, is I don't think it poses a conflict of interest. But my more fundamental view is whether there's a conflict of interest or not is between Watts-Guerra and their clients. And what bothered me was the attempt by this handful of people who are opposing the plan to try to get all 13,000 of the votes cast by Watts-Guerra's clients disqualified. There's no basis for that in either the law or in basic principles of equity. So we filed a couple of things this week setting forth the bankruptcy law on this and saying, look, we don't think there's a dispute or a conflict here, but if there is, that's between Watts-Guerra, their firm and their clients. It certainly should not be used by opponents of this plan to be able to disqualify a massive number of votes. That would not be fair to those victims. If you believe Watts-Guerra has done anything wrong, by all means, punish them with the bar, but don't disenfranchise the victims. And we don't think that's going to go anywhere, but that is an issue that's come up, so I wanted to bring that up. The last thing that I wanted to say before we open it up is that we've been doing a regular town hall on Saturday, and it's important for anybody who wants to be able to come onto that. So there's 2 ways you can do that. One is you'll receive a phone call, and the other is you can log on and listen to it either through Facebook or online. The final thing I want to say on that is that our group is just the group that we have. We are not involved financially with Watts-Guerra, with any of these other groups. We don't split fees with them. They're not involved in your case. What we've done is a number of us who have the same view in this case, who represent, again, about 70% of the people have come together and worked together. But, you know, there's no fee splitting, there's no joint venture, nothing like that. And then again, finally, for the town hall on Saturday, there will be about 10 attorneys participating. I'll be one of them. So if you would like to join, you're certainly welcome to. I don't know that it's going to be much different from what this is, but if you're interested in getting perspective from other attorneys, I encourage all of you to join. The attorneys on there are all very good, and they all know what they're talking about. Okay, so that is my spiel. Let's open it up and answer any questions that anybody has.
And if you have a question, you can unmute yourself.
Hi, my name is CJ Minor. I own a property with an ex who was living on the property at the time, when the insurance came through, he had changed the insurance into his name only, therefore he got the check only. What will happen now when our property is settled?
Okay, well, first of all, I'm sorry to hear that, CJ. That is very unfortunate. That does happen from time to time. It creates a problem because what happens here is that the duty of the claims administrator is to determine what PG&E's liability would be and what they would have to pay out. And because of the subrogation settlement, PG&E, and now the trust, because the trust stands in PG&E's shoes, is entitled to an offset for the full amount. So what we are going to need to do is sit down and look at what interest your ex had in that property. And a lot of times, because this unfortunately has happened in the past, what we're able to do is to say, okay, let's split the real property interest 50-50. And if we take the money that the spouse who took the insurance received, usually there's enough in the uninsured portion to make up for that, so it evens out. In an ideal world, that's what we'll be able to do in your case, but we may not be able to. It may be a situation where we may have to pursue legal action, but that's something that we should look at on a case-by-case basis. So if you want to just give me an email about that either today or tomorrow, that's something we should start looking at sooner rather than later.
I have brought it up with Joanne Estrella.
Okay.
So
Yeah, as long as she's aware of it,
Christy.
we want to be able to address that early on and to get out ahead of it, because what we don't want to do is to have your ex make a claim and essentially double recover. Anything that is not insured,
Correct.
if he took that insurance amount, we want that to go to you.
Well, it gets a little more complicated. We were never married, and I actually put the down on the property. He moved in with 3 hefty bags and a coffee cup, but I left after 8 years because of abuse, and
Oh, I'm sorry.
he stayed on the property, and he
Okay.
feels that since he made all of the payments from that point on, that he deserves everything that comes to the property.
Well, and obviously people are entitled to feel however they wish, but that is certainly not the law. And so, yeah, this is a complicated situation. I'm sorry for what you've gone through. We certainly are going to have to dig into it, but I can tell you that that's not the way the law works. You each have an equitable interest in it. And so what we're going to have to do is get down into the weeds, look at who paid what and who contributed what, and then we can figure out how that's going to work. So again, it'll be a case-by-case determination, but it's not a situation where because you weren't living there, you're somehow out of luck. You have an interest in the property, and we can definitely get you compensated for that.
Okay, thank you so much.
Sure.
Well, hello, am I talking to you guys now?
Yes.
Okay, well, we have been relocated down to Phoenix, Arizona from Paradise, where we lived for 40 years, raised 4 kids on that property. My least concern in my life is pots and pans and paper towels and things like that. We lost animals that were companion. We lost our children's ceramic handprints that they did when they were in kindergarten. How can you ever, I mean, we didn't even know when the content list, it was just a joke. It meant nothing to us. What do we have? I mean, that's what I sent in a letter. We don't even know what we are.
Yeah.
You know what? A year and a half later, and that's a fucking mess. I just hate it. We hate it. Our whole life, we had a life, an age in place. We're 70 and 77 years old. We had a age in place, remodeled home. My granite was going to go in my brand new kitchen 2 days after the fire. How do you ever recover from that? Our life is upside down. We don't care about pots and pans.
Right.
Just,
well, what you've described is really the key issue here, and it really is the touchstone of what we're talking about, because you can replace pots and pans. You can replace all those things, but what you can't replace are what you're describing. They're known as cherished possessions, and that would be your child's ceramic handprints, the photos you have of a loved one who's deceased, anything along those lines. An example I give is my grandmother, who I was very close to, passed away earlier this year. And one of my favorite things that I own, I mean, it's not worth anything in terms of fair market, is a picture I have of her. And that, again, to me, that's one of the most valuable things I have in my house. But when you look at it from an economic perspective, again, it's got no economic value. So that's what you're talking about. And what you're talking about is what really gives life its value. The fact that you were in a community, all of the things that you had. And there is no easy way to just, plug in a formula and come out with what it is. So what we do in those cases is we list out what the cherished possessions are, and we do a detailed narrative where we describe the difference between what your life is now and what it was before the fire, and how this fire has changed your life. And then we look at, and those damages are called nuisance damages. I know it's much more than a nuisance, but in the law, the cause of action is called nuisance. So that's why we refer to them as nuisance damages. They're also called Kelly damages, which is the main case in this area, case that came down about a decade ago, Kelly v. CB&I Constructors. And it's the one that really set out how much you could recover here. Kelly was a great case. We cite it in every one of our mediation briefs, and we say, look, under Kelly, this is not just compensable, but this is a huge component. In some situations, it's the main component of damages. And so we describe all that, and then we put in numbers based upon what prior juries have awarded, what arbitrators have awarded, and settlements that we've seen in similar types of cases. But it's a lot more art than science. And you're right. This is a lot more important than pots and pans. Things like that can be replaced. What you've lost really can't. It's a poor substitute, but what our system does is we ask for money and we award money for those types of losses. And that's why, these cases have the damages they do. And that's why those damages are so high, because what you're talking about is really what makes life, I don't want to be dramatic and say worth living, but really where the joy in life comes from.
It is what's worth living.
It's what really gives meaning to your life. And so that's what we're talking about. And that's what, unfortunately, so many people have lost as a result of these fires, when they lost their home, their community, and they're displaced like you are. So that's why our demands are so high. And, that's how that process works.
If we've already completed a content list, which I couldn't do it, mentioned a few things like our Kit Kat, the Brat, the Calico, Kitty Cat, Tiny Tina Ballerina, can't replace her. What do you do if you've already submitted your content list? And I mean, there's a million things I can't remember in a moment, but I can remember as days goes by. It's been a year and a half. Cannot possibly think of all the things I've accumulated in my life.
Understood. You can always supplement. So you can supplement. That is not a problem. What I would recommend doing is really going through and picking out the main items. So when you talk about the ceramic handprints, really go through and list what the main cherished possessions are. And then in terms of your contents, if you need help with that, a lot of our clients find that it's helpful to go room to room. So you just imagine yourself sitting in your former living room and you say, okay, I'm sitting on my couch, I'm looking forward, what do I see? And when you do that, a lot of times it just automatically puts you back to where you were and you're able to jot that down. For some people, it's too painful to do that, and we completely understand. But I would just encourage you, as much as you can, please document what your losses are, because that increases the chances that we can get you fully compensated.
And because we have reasonable insurance, we were paid 75% out of our, content coverage. I did mention that in the content letter. So I thank you, and maybe I will do an amendment as days go by. I remember things that, I'll never have. You go, oh gosh, I had that. Oh my goodness, let me go get it. Oh, I don't have it anymore. Those types of things. So thank you for your answers. And yeah, wish I had my house, wish I had my home, wish I had my life.
Well, we'll see if we can get you back there.
Thank you.
Anybody else?
Yeah, do we have other people that have questions?
If for some reason you're unable to unmute yourself, just give me a wave or.
Yeah, please raise your hand if you'd like to ask a question. And certainly nobody needs to feel compelled, but I'm willing, I'm happy to stay as long as anybody has questions.
I have a quick question if you don't mind. Can you hear me?
Please. Yes, we can hear you.
Yeah. Okay. I was in the wildfire in the Coffee Park area. It's been almost 3 years ago, it seems like. My question is, I know you were talking to the last person with regards to make a list. When are we supposed to have that list done? Because I didn't know that I know originally when we first started, my insurance said, hey, are you sitting down? We're not going to make you do that list. We're just going to pay you out, which was wonderful,
Yeah.
but like the person before said, it's extremely hard to do that because, you'll walk into a room and all of a sudden you get so emotional because, you remember something. And I was one as well. My mother had just passed away. I had all her stuff and we were going to go through it with all the siblings. And of course, can't do that anymore, but it's just, it's that kind of stuff. Or, I had the week before I put 3 big bins together. I have 3 children and I put everything from their birth all the way up to current. And I was just getting ready to give them to them the following week so they could share with their children, my grandchildren. And that, just the thought of that where you think, oh, why didn't I grab that? Why didn't I grab those? It's just that kind of stuff. And it's hard to put a value on it.
Oh, absolutely.
So,
no, and that's it. Again, that's a very good question. And what I want to really stress with everybody is this. The goal here is to help all of our clients, and we don't want to add to your stress. So there are going to be situations where it really is more stressful and it just isn't worth it to make the list. That said, to the extent you can, we really encourage it simply because the only way I can know that I've gotten you all the money that you're entitled to for your personal contents is if I know what you had. And we have the memory jogger. Anybody in our office, we're happy to sit down with you. We can't do face-to-face meetings at least for another month, but we can do it on the phone. They can go through it with you. And so I would really encourage it. In terms of timing, in an ideal world, we'd like to get that within the next 30 to 60 days. And the reason for that is, again, I know this won't happen, but my goal is to have every one of my clients have submitted all the documents we need so that we can submit every single one of them the first day that the trustee and the claims administrator open the process up. Because it's going to be a first come, first serve. Now, it won't be like the PPE or any of the PPP, the loans where, if you didn't get it done in time, you're out of luck. The trustee has a fiduciary duty to everyone. And so while we hope there's going to be 100% paid, if there's going to be a reduction, it's going to be on across the board. So in all likelihood, we've talked about this before, he'll pay out an initial amount, probably about 80%, and then hold back an amount until he's sure that everyone can be paid 100 cents on the dollar. So if you're one of those people that are farther back in line, don't worry, you'll receive the same percentage. But again, I just want to get my clients paid as quickly as possible. So the sooner you get that to us, the sooner we can submit it and get it in. But again, that said, we have clients that are at all different paces. Some of them find it therapeutic to get everything done and get it submitted early. Other people say, you know what, I need more time. Both of them are fine. Take your time. If you can do it now and submit it within the next 30 to 60 days, that would be ideal.
Is there a list that you provide us, or we just email it, or?
Yeah, no, we can give you what we call a memory jogger, and this is something that we put together over the years. We based it on different things that we got from insurance companies, from independent claims adjusters, and it's very, very lengthy, but it's organized by room, and you can just go through and check off what you had, and then if you know what it was, for example, you look at your living room. Okay, I had a TV. It was a 30-inch LG, and you put the year in. then you'd put the couch in. If you know what kind of couch, fine. If you don't, that's fine too. And you just list everything that you had, and you go room by room, and it has the items that we typically see. So all you do is just check it off. And then again, if you know what the item was and how much you paid for it, you put that in. If you don't, that's fine. We can provide that later, but we just want to get everything that you had.
List. Okay. Okay. And how do we get that list?
Oh, you can just email the office. So if you've been working with any specific person, just email them. If not, just email me, and I'll have my paralegal Bersabe send it out.
Okay, perfect. Thank you so much.
Sure. Yes, we have Mr. Harris. Mr. Harris, you're muted.
No, on his end. He's unmuted, but we don't have, maybe his mic is not.
Is your mic working? Because it says unmuted, but we can't hear you.
Yeah, we have him unmuted.
I'm sorry, we're not hearing you. Can we do a call in, should we?
Sure, you can call.
I'm gonna give you a number and you can call in, and then we can do it that way. Go ahead.
You can call 619
619
537
537
9995.
9995.
Mr. Harris?
Hello?
Yes, we can hear you now.
All right. Okay, you got me?
Yes, we can hear you.
Okay. This might be a question that needs to be off the Zoom or whatever, because we built our house and sold it in 11 months from the fire income.
Okay.
Done. Went through a lawsuit of being underinsured with Farmers Insurance. Done. Turned in massive lists, went through that whole process and everything with Farmers and doing that. My question is, approaching these claims people that they're hired that are going to go through what we're going to turn in with our lists and everything. What is there a recourse that they're going to dive back into the lawsuit from Farmers? Other lists that we put in, are they going to dig up that stuff, or should we just roll in the list of all our losses by room, from garage to underinsured, and should we just turn that over to you?
Yes. Yeah. So the question had two parts. One is fairly general, and then one is specific to Mr. Harris. And there's a handful of other folks, but it only applies if you had a bad faith suit against your insurer. So the first question is, when you have sold your property, and in Mr. Harris's case, they rebuilt and then they sold, you are going to be limited to diminution in fair market value because you no longer have the intent to repair the property. So for the real property, that's where you are. You can certainly recover certain improvements that you put in prior to the sale, but in terms of any future improvements, for example, trees that were destroyed but that were not replanted, we won't be able to recover those. So that's issue number one. Issue number two is, if you were in a situation where your insurance company essentially lowballed you and did not pay you a fair amount and you had to sue them, does the other side have access to that file? And the answer is yes. It will be contained in the insurance claims file, which is available. So everybody's insurance claim file is available, and it's one of the things that the claims administrator looks at to, number one, verify how much you receive for insurance, but also to check different claims that you make, just to vet each claim and make sure that they're legitimate. So what I would recommend is that you build on the prior lists that you made, and if you had personal property, things like that, you take those lists, bring them over here, And then if there's anything that you now remember that wasn't on the before, you add to that and go ahead and submit it.
So I understand that. We obviously didn't get to a trial and get to a jury against them in our underinsured case. And they were beating us down at what they did, and we did settle with them. And they were arguing our list, which is accurate, but they were trying to make us prove things like that. So are we going back through that process again? I'm going to turn in the same list.
I see.
But that's what it was.
Right.
They beat us down and we're going to make us do all these other things. Would let us bring workers in because of immigration status. I mean, there was just this whole thing that was going on.
Yeah.
My question, and then so they kind of strong-armed us into settling, and I don't want to go through that again.
Right.
Because we are owed what was lost.
Sure.
So I don't know where I'm coming from at this angle now.
Absolutely. So to answer that question, the issue, I think the main question is, what is that process going to be like in terms of personal property? And I think it's going to be very different than it would be in a purely adversarial case. If, for example, we were still suing PG&E as opposed to having a trust.
Sure.
When you have the defense attorneys, they do tend to go through things with a fine-tooth comb. With the trust, I think it's going to be more, they're going to look at it more on a macro level. So as we've talked it over with the trustee and the claims administrator, I think what they're looking for is they're going to, and we've been working on coming up with what this percentage is, but they're going to be looking at specific percentages based upon what the cost to rebuild is, the neighborhood, things like that. And they're going to see where they would expect the personal property to come out. So if, for example, your list results in a claim of about 50% of the cost to rebuild your home, my belief is that that's going to be within the reasonable level. And so they're probably going to either approve it or have very minor things. But it's not going to be, for example, okay, you say you had 5 salt shakers. Let's really go through this. We think it's only reasonable to have 3. Nothing like that's going to happen.
Okay. And so being underinsured, which I'm sure everybody on this phone call or on this video has been through or whatever it is, and forget the lawsuit on the side of it, if we have documents that prove how much it cost me, because I have rebuilt, do those documents and financial statements that they, should we provide those to you? Forget the contents. We got that covered.
Yes.
Like other things that were cash, doing things. So are those things that you guys want to go to the people? No.
Yes. So the question was, if you actually rebuilt, do we want the cost to rebuild? The answer is yes, absolutely. Now, whether or not you can recover the amount you paid depends upon whether you built substantially the same house. For example, a lot of people choose to make modifications, and that's fine. You have every right to, but the amount that you're entitled to be compensated is for what you had. So if you had a 3-bedroom house and you decide, you know what, it makes more sense for me to have a 4-bedroom, and you add another bedroom on, they would have to pay the costs to build the 3-bedroom and everything else, but not the 4th. And so it can be very helpful for us to see what was actually spent. But I just want to caution everybody, if you changed significantly, adding bedrooms, adding significant square footage, things like that, then you're not going to be able to recover the full amount because, again, they're only required to compensate you for what you had.
Well, you just do the square footage on what the original square footage was.
Exactly. Yeah.
In my case, my house was for A. I didn't what the old house was.
Okay.
I understand that.
Yeah.
Okay. I just want to know, I want to be prepared and to give you guys, to pass on to them exactly what I don't want the back and forth. I'm going to go, here's the document. There it is.
Understood. Understood. Yeah, makes sense. Okay.
Well, thank you very much for the answers. You guys on email.
Okay, sounds good. Okay, what other questions do we have? Who has a question?
I have one that was submitted.
Okay.
What elements make up the amount you will demand for each claim?
Okay, so the question is, how do we determine the amount of the claim? What do we look at? And so we look at a number of factors. We start with real property. If you own real property, then we look at several different factors. The first is your home, or if it was not a residence, but a commercial, the commercial structure and any other structures. If you had a shed, if you had a workshop, detached garage, all of that. And we'll get a contractor who will give us an estimate to rebuild. The next thing we look at is the landscaping, the hardscaping, anything like that. Trees, anything that goes along with that. We have experts who look at that and give us a report as to what it would cost to replace that. Then we look at, and this is not applicable in every case, but it is in a significant number, usually about a third. We look at erosion, any issues there, particularly if you live in hilly areas, this can be a huge problem. So that's something we look at as well. We have a professional engineer who's a hydrologist, and she'll prepare a report on that. After real property, and there are individual things that come up, but those are the main ones for real property. After real property, we would look at personal property. And that's something that we've gone over, but we look at what you received for personal property. Then after that, we look for any kind of lost earnings. If you weren't able to work for a week or two, in the less standard cases, somebody who ran a business out of their home, had that destroyed, those kinds of things. And we come up with a damage amount for that. If there's any other economic loss, for example, if you had alternate living expenses that either weren't covered or were over what your coverage was, would put that in there. Sometimes people have personal injury. Sometimes they had to pay a private adjuster. All of those factors will be put in. Then we'll deduct what you received in each one of those from insurance, and that will give us a final number for your economic losses. We take the economic losses, and then on top of that, we put the attorney fees for those and the costs. So that's whatever the contract is, and then whatever the costs are, put that on top of it. And then on top of that, we put the non-economic damages. And that's what we were talking about earlier. So we talk about the cherished possessions, the fact that your community was destroyed. If, for example, you lived in Paradise, if you lost your home, then obviously that's a big factor, because not only did you lose everything, you had to start over again, all of those things. And then the final thing we look at is your proximity to the fire and where you were. So again, the two components of non-economic damages are how it's impacted your life, how your life changed, and your proximity to the fire, and whether you were in fear for your life or saw close relatives in fear for their lives. We add all that together, and those are the elements that go into the demand.
Anybody else?
Okay, do we have any other questions? All right, so I want to remind everybody, if you're interested, we have a 12 o'clock town hall. There'll be a number of attorneys, again, probably about 10, could be a little less, but there'll be several of us. It should be generally the same as this. And as always, if you have any questions, please call or email me. Thank you all very much, and we'll talk next week on Thursday. Take care.